You sued your doctor for medical malpractice, claiming that he was careless, causing you significant harm and injury. During the course of your lawsuit, the defense lawyer, the attorney who represents the doctor whom you have sued, will have a chance to question you. If he asks you inappropriate questions during the course of your pretrial question and answer session known as a deposition, will you have to answer those questions? You want to know the answer? Come join me on this walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is maybe yes, and again, maybe no. So what do I mean? All right, so now you sued your doctor claiming that he was careless and that he violated the basic standards of medical care, causing you harm and injury. You have a medical expert who confirms that you have a valid basis for a case. Now the defense attorney will have an opportunity to question you, to learn from you, to find out from you exactly what happened in your own words, to explain what it is that was done wrong and what injuries you have because of whatever the doctor did carelessly. So now, this is a pretrial question and answer session that takes place in our office. There's no judge there. There's no jury there. Instead, it's me. I will be there with you. The defense lawyer will be there. And there will be a court stenographer there. We call them a court reporter, to record all of the questions that you are asked and all of the answers that you give. Now, you should know something important. The answers that you give carry the same exact weight as if you are testifying at the time of trial. The only difference is there's no judge and there's no jury there. Okay, so now during the course of questioning, the defense attorney asks you a series of questions and you hear me object. Objection! And now I say, do not answer that question. And now the defense lawyer and I start arguing. We're arguing about whether or not my objection is appropriate. We're arguing about whether or not the question is appropriate. And what happens then? You will hear me object. And when I object, you have to wait until I tell you whether or not to answer that question. In most instances, during a pretrial question and answer session known as a deposition, by the way, we also call this an examination before trial, in most cases, I will then tell you, go ahead and answer the question. And you might be thinking, I don't understand. You just told me and told everybody in the room that the question was inappropriate. And now you're telling me to go ahead and answer the question? That makes no sense. The answer is, in many instances, when I believe the question is inappropriate, I am required to put that objection on the record, which means I make a verbal statement, the court reporter writes that information down, and now I have to tell you to go ahead and answer that question, even though I believe that the question is inappropriate. Now, why is that? It means I have now preserved my objection. It means I have made an indication in the record so that now, later on at trial, or later on if somebody presents this transcript to a judge, now the judge can see exactly what the issue was, why I had a problem with the question, but we are required to tell you to go ahead and answer that question. Why? Because this is known as discovery. It is the discovery phase. So even though the question is inappropriate, and the answer might be inappropriate or not related to the issues in the case, or to the defenses that are being raised in this case, it's discovery, which means the defense likely has an opportunity to learn about it. Attorneys often get into arguments about what is an appropriate question. There are some questions, for example, in a wrongful death lawsuit, where the defense attorney turns around and says, hey, Mrs. Jones, how much life insurance did your husband have? And you know what I say? I say, objection, do not answer that question. Why is that? Because the amount of life insurance that your husband may have had has absolutely nothing to do with the claims that we are making against this careless doctor. Nor does it have anything to do with the amount of damages that we are claiming in this case. Nor does it have anything to do with the defenses that are being raised in this case, which are, and what are the defenses? Hey, we did nothing wrong. Even if we did something wrong, so did you, Mr. Patient. And if we did something wrong, it didn't cause or contribute to your injuries. And guess what? Your injuries really aren't that bad. Whether or not you have life insurance proceeds because your husband took out a life insurance policy before he died, guess what? That's got nothing whatsoever to do with this case. And there's case law to support that. In that instance, where it is totally improper for the defense to ask you that type of question, I will tell you, do not answer that question. And the defense lawyer may still disagree. He can disagree all he wants. And if he wants further action, he will then have to apply to the court, make a written formal request to the court, and say, Judge, Mr. Oginski didn't allow his client to answer this question, which we believe is appropriate. Then I will have an opportunity to respond to that and explain why it is a totally inappropriate question for this procedure, this deposition. So there are some instances where I am fully within my right to tell you not to answer a question. And you should know two more instances where that will happen. The first is where the question is palpably improper. Now, what does that mean? It means where the question is so off the wall that you clearly should not be answering that question. So, for example, the defense attorney turns around and says to you, "Hey, Mr. Jones, how many times do you beat your wife each night?" And you turn around and say, "What? What are you talking about?" That type of question is palpably improper, has nothing to do with the claims in the case or the damages or the defenses, and should not be answered. The other type of question that typically we are allowed to tell the client not to answer would be where the defense attorney asks a question about a conversation that you and I have had. "Hey, Mrs. Jones, did you talk to your attorney Oginski before this questioning?" "Yes." "Tell me what the two of you talked about." "Objection!" That information is confidential and privileged. Do not answer that question. So then I would be fully within my right to tell my client not to answer that question. So, getting back to the title of this video, are there instances during the course of your deposition where you will be asked a question to which you believe is inappropriate and should not be answered? The answer is yes. There may be times where the defense attorney asks you a question to which is not appropriate, to which I go ahead and object, but I still tell you, go ahead and answer the question. And there are very few instances where I turn around and tell you, listen, that question is totally inappropriate. Do not answer that question. You know, I realize you're likely watching this video because you wanted to join me on this walk around the neighborhood. No, I realize you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York, but you have not yet started a lawsuit because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.